Welcome to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. Today, we're talking about the Catholic Church. Cases that should have gone to the Supreme Court of Canada, but didn't. In the course of dealing with claims against the Catholic Church, they resorted to their insurance company to ask for them to pay out claims related to the sexual abuse committed by priests in the church. Aviva Insurance Company was one of the insurers of the Catholic Church. They paid out a single claim and then denied the Catholic Church coverage for any future claims. As a result of this, the Catholic Church developed a process by which it would voluntarily pay out claims made by survivors of sexual abuse against the Church in order to mitigate the amount of damages that would be ultimately awarded. After paying out several claims, and after several claims were settled in court, the Catholic Church then sued Aviva Insurance Company, asking for them to recompensate them for the amount of money that they'd paid out. The court ordered that the claims that proceeded in court were claims that should have been covered by the insurance and ordered the insurance company to pay those claims. However, the claims that were settled through the separate process set up by the Catholic Church were not ordered to be paid out by the insurance company and were found to be voluntarily payments exempt from the insurance contract. The Supreme Court of Canada denied leave to hear the case. And this case raises an important issue. What happens when there's such a huge historical issue of abuse, where an organization is finally taking steps after years and years and years to address it, and when asking its insurance company to step in and do what the insurance company is there to do, they're initially told, yes, we'll cover you, and then no, we're not covering you anymore. Rather than leaving these people in the lurch for longer, letting survivors of abuse suffer for longer without any acknowledgement of the wrong done to them or any compensation for the harm that they suffered, the Catholic Church did what appeared to be on its face the right thing. It adjudicated the claims and it paid out the claims that it determined to have merit. By saying that the insurance company wasn't liable after the insurance company had ultimately wrongfully denied coverage, the court essentially said that the Catholic Church was both wrong to mitigate its damages and wrong to help out survivors of abuse that it had caused to be in that position. The Supreme Court of Canada, I think, missed the point here, which was not about whether an insurance company needs to be liable for voluntary payments, but whether an insurance company needs to step up when it's time to do the right thing for survivors of abuse. This was an opportunity for the Supreme Court of Canada to do something to help people who suffered at the hands of the Catholic Church when the Catholic Church was finally in a position to acknowledge what it did wrong. And by making the insurance company not liable for what happened when the claims were settled by the Catholic Church outside the court process, it ultimately said that it's okay to re-traumatize survivors of sexual abuse by making them go through the court process and relive those experiences rather than resorting to a more efficient and convenient adjudication process with the Catholic Church. This was a grave missed opportunity that unfortunately ultimately negatively affected survivors of sexual abuse. And I hope that if another case like this ever has to make it to the Supreme Court of Canada, they'll think about it differently. You're watching Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases that should have gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Brazen Bull Creative puts together these videos. Please like, subscribe, share with your friends, and tune in next week for another exciting episode.